Hello everyone. So today I wanted to look, and I'm going to do 4 videos on this, but I'm going to look first at the first major chance of appeal for Amber Heard. Now she, according to Andrea Burkhart's analysis, which I'm going to believe, she had 4, which were number 1 I'm going to be looking at today, which is the UK judgment. Number 2, of course, is whether it should have been heard in California instead. Number 3 being the damages, and number 4 being the medical records. Possibly number 3 the medical records, number 4 the damages, but they're the 4. So I'm going to be looking at those 4, and the first one I'm going to be looking at is the UK judgment. Now I'm not a lawyer, so I'm not looking at this from a legal point of view, I'm looking at this from an analytical point of view. So what I'm going to be doing is I'm going to be giving a sort of a chance. I'm going to be saying how much of a chance it is. Now lawyers don't do that. They don't tend to do that. They always say, oh, it's a chance, it's not a chance, and all that sort of stuff. So I'm not going to do that. So what I'm going to start off with is I'm going to describe the situation. So what we had was that Johnny Depp sued the Sun newspaper, plus I believe it was an editor called Dan Wootton, and that was about them publishing what he perceived to be lies about him and about his relationship with Amber Heard. He didn't sue Amber Heard. Now I don't know why he didn't sue her, but it can be assumed that he believed that she'd told the truth and that the newspapers were lying. And of course at that stage Amber Heard had signed a declaration in court in relation to their divorce proceedings, where she promised not to badmouth him. So if she did badmouth him to them, she was in violation of their divorce proceedings. So he had every reason to believe that she hadn't badmouthed him, because if she had, he could sue her and get all of the money back from the divorce. And in fact, he still could. So, you know, that's $7 million back from the divorce. Of course, if she's pledged it away and donated it away, then he wouldn't be able to get it back because it's gone to charity. That's a bit mean. But since she hasn't given that away, he could at any stage open up a divorce proceeding and ask for, or not a divorce proceeding, but a violation of the divorce proceedings, which would be sort of contract law. He would win really easy. So that would be why he would not have sued her. That's the probable reason. I don't know for sure if that's the reason, but he would assume that she wouldn't have violated that. Well, that was a contract that they had in relation to their divorce, and he signed it too. He wasn't allowed to badmouth her. So in the context of the proceedings, it proved that she did badmouth him and that she was in violation of the divorce proceedings. That also came up in the US trial. He is still allowed to sue her to get that money back, but of course it's not really about the money. This is about restoring his reputation. He wants to win. If he goes to a divorce thing and, you know, and proves that she badmouthed him, he might get some money, but he's not going to restore his reputation. So that's a reason not to do that, and that's a reason not to sue her. So now we get to the situation. So we know that he didn't sue her. She appeared as a witness. Now, of course, she was not compelled. As a witness, she was compelled to tell the truth, but she wasn't compelled to tell everything. In other words, she could essentially control what she was willing to talk about, as all witnesses can. Now, of course, you're there on the stand. You're going to have people from, you know, lawyers from both sides ask you certain questions, and you have to answer those questions. But they don't have what they call discovery. So discovery is a situation where you compel both sides to produce relevant evidence. And so they couldn't compel her because she was not a defendant. And, you know, so they couldn't ask for proof about certain things. Now, of course, the Sun newspaper asked for some proof, but only as far as what helped their case. They couldn't, like Johnny Depp's side couldn't ask for things that helped his case. So the result of this is that her testimony was less complete than it was in the US trial. So her testimony, her level of evidence was a lot lower. She had witness level of evidence instead of defendant level of evidence. And that's really important because, as it turned out, once we got to the discovery, we found out that she was lying about the whole thing. And I can say that pretty clearly. That was proven in a court of law. So I will say she lied about everything. And I'm not saying that as an opinion, I'm saying that as a proven fact, proven in the court of law. If there's an appeal, I'll no longer be able to say that, and I may have to change that if the appeal turns out that she didn't lie about everything. But at the moment, I'm saying she lied about everything, or about at least substantially most things. And therefore, if we sort of look at that original decision, and in the UK, we can say that, well, there's still no avenue for an appeal there, because still the newspaper did nothing wrong. You would just change the wording of the document, because it's not the newspaper's fault that she lied to them. That makes it her fault, but he didn't sue her. So therefore, the newspaper can still win. Now, you probably change the argument, and yes, she's then open for proceedings against her for perjury in the UK, and they could well do that. And perhaps they're waiting for this appeal and see if that place works, and if the Court of Appeal don't agree with this one, she could be sued for perjury in the UK trial. So the UK, someone in the UK, maybe, I think Adam Waldman tried to open a case of perjury against her. He could now. He could then say, well, I'm going to go to the police and say, hey, she committed perjury. Now, that wouldn't necessarily change the decision or order a new trial, but it may warrant some amendments to the judge's remarks, or maybe some additions. But there's a world in which the UK trial was fundamentally, at least overall, correct, and the US trial was as well. And that means, therefore, that there's not really any argument towards overthrowing the US trial because of the UK one. And the other thing is, the US trial was more comprehensive. It went for 6 weeks instead of 2. And therefore, if there was a compulsion to essentially pick which one to pick which one has the greatest merit, you go for the one with a longer trial, with a jury trial, with Amber Heard more compelled to give evidence. And that is the US trial. So if one of them has to be thrown out, it would be the UK trial, not the US trial. The only argument to suggest that the UK trial should be the one that's kept is if you have the argument that that was the first trial, and therefore you've had one trial, you don't have any more. But the basic principles of fairness say, well, if we found out that a decision was unfair, even if it was technically the right decision, we're not going to accept that. We're going to go with the fair decision. And if you look at this and you compare the two, it is clear that Johnny Depp's decision, the US decision, was the fairer of the two decisions. And so if you were going to overthrow that fair decision based on a technicality which isn't exactly a correct technicality anyway, and replace that fair decision with an unfair decision or a less fair decision, that would be manifestly unfair. Now, when you get to the Court of Appeal, you have to have issues that are basically overthrowing the whole case, or at least a major part of the case. So you can have a technicality, that's fine. You can have as many technicalities as you want, but that technicality has to lead to a gross mistake in decision. So, for example, one Court of Appeal case was heard reasonably not that long ago was George Pell. So George Pell was a Catholic priest, or I think he was a cardinal actually, and he was found guilty in a court of sexually assaulting 2 choir boys. One of the choir boys was dead before the case started. Now, that was won on appeal, and the reason that it was won on appeal was because there was no actual evidence that he did it. In fact, there was evidence that he couldn't have done it. And because the jury weren't instructed properly about that, it was a bad decision by the jury. So in that case, the Court of Appeal threw it out and replaced it with innocence. And that's because in that case, it was a manifestly wrong decision. It was just simply a decision that the jury couldn't have made based on the evidence. Now, usually we don't appeal jury decisions, but in that case we did. And it's not usually based on a minor technicality that makes no difference to the outcome. So it's based on a big issue, which in that case was, it was just simply impossible for it to have happened, given the evidence. And it wasn't really open to the jury to make that decision, and the jury would have made the decision based on other factors that are not based on the facts, such as perhaps they didn't like Catholic priests, or they didn't like the idea of someone doing something like that. So that's when you get an appeal granted. Now that's not the case in Amber Heard's case, not for this one. I'll go over the other three later, but this one, I'm going to say 0%. I don't even see any world in which a fair judge in a court of appeal is going to even consider this. That's it from me. Bye bye now.